Good afternoon, ladies and gentlemen who have joined us on this Dr. Fundi channel, joining us via Facebook, joining us via Instagram, via YouTube, via Twitter, and also via the Dr. Fundi channel. My name is Dr. Fundi Lenyati. I'm a family physician, but I'm also a host on this channel. Today, we have an interesting topic. Our topic of discussion today is a discussion around matters of law relating to vaccination. There is a question that has not yet been answered here in South Africa, but it's a question of something that's possible and something that may happen as South Africa rolls out its vaccination program. And the question is, can an employer force an employee to take a vaccine against COVID-19? So can an employer force an employee to take a vaccine against COVID-19? So that's the question that we are going to be grappling with today. Now, to help us with that discussion, I've got a special guest, Mr. Danie Pretorius. Danie Pretorius is an attorney. He qualified in BA Law, LLB, LLM in Law and Political Sciences. He's a director and an EXCO member at Flaxmans Incorporated in Johannesburg. He is the head of the employment law practice within Flaxmans. He's described as a highly reputable employment lawyer and greatly experienced commercial litigator, as well as somebody who's very active in arbitrations and dispute resolutions. So his areas of expertise are dispute resolution, negotiations, collective bargaining, reorganization and retrenchments, corporate law, civil litigations, and corporate governance. Mr. Pretorius, welcome to the Dr. Fundi channel.
Hi, Dr. Nyati. Thank you for having me. It's nice to chat.
Yes, we have to chat, man, you know, and in the process, empower each other with knowledge. So you are very experienced in matters of law, and I'm very experienced on matters of medicine. But on this topic today, I am a layperson, so I'm here to be educated. And many of the people who have joined us today, you know, the ears are waiting to be educated by you.
Yes, I think it's a topic that we're only really starting to lay some of the bricks. So it's not. I think a lot of it is groundbreaking stuff, and I'm not sure that there's a lot of precedent for any of the views that I may share with you. But I think it's mostly based on basic principles and you know, going back to the general principles of employment law.
Yes. So, you know, sometimes during the week, I came through an article which was talking about the successful vaccination program in Israel. In fact, Israel has got the best vaccination program in the whole world, because in terms of the rankings of vaccination, they have been able to vaccinate 94 out of 100 people in their country. Now, there's no country that has done as much. However, there are people who are opposed to COVID-19 vaccination, even in that country. So I read an article that a certain company in Israel has introduced some benefits, employee benefits, that can only be enjoyed by those who have taken the vaccine. I also read in the same article that in the US, there has been a restaurant that has dismissed an employee because the employee refused to take a COVID vaccine. Now, yes, that is something that is happening out there amongst the countries that are ahead, because the US, in terms of the pure numbers, they are the #1 country in terms of vaccinations. About 85 million doses have already been given to people in that country. About 53 million, at least they've had one vaccine, and about 22, they've had both jabs. That is, jab number 1 and jab number 2.
Yes.
So they are leading in the world. So I thought we are going to get to a point, possibly by the third quarter, we're going to get to a point where in South Africa, there is now the phase 3, where people are being vaccinated, en masse. And employers are actually allowed, in terms of the plans of vaccination, to actually vaccinate their employees. So the question then is, when that happens, if there are employees who refuse to take a vaccine, what are the legal considerations? So I came across your article that appeared on the newsletter of Flaxmans, an article that appeared on the 2nd of December last year. And I felt it does justice to some of the legal considerations about this topic. So just to kickstart then the question, what are the rights and obligations for employers when it comes to issues of health and safety in the workplace?
In terms of the Occupational Health and Safety Act, every employer is obligated to provide a safe working environment without any risk. And if one considers that and the massive obligation that it imposes, most of my article was premised on that obligation that employers assume when they employ people, is that they must ensure a safe working environment. Now, people very quickly may say, yes, but everyone who can still stay at home and work from home. But, in terms of our employment law, and I think most employment law is the same, there's a principle called managerial prerogative. And it is, if the company feels it will be better suited to work from the workplace, everyone must get back to work because there's more cohesion and camaraderie and a sense of purpose and all of those things. It would be managerial prerogative to say, we want people to return to work at some point. I'm not suggesting now because there's too little vaccines yet to go around. But at some point that would come upon us. And I think there's two cases really to differentiate. The one would be employers who really would need to do something like this, which are like factories or mines where people work in close proximity, and it's inevitable that they cannot really do anything but work like that. Now, in my view, those entities would have a very strong case to insist on vaccination. But even a small business where the owner or the company comes to the conclusion that its business would be better served or perform better by insisting that everyone comes back to the office or the workplace, call it what you will. My view is that even that employer would be able to insist on vaccination.
Yes. All right. So, so on one side, then the employer has this obligation to provide a safe and healthy work environment where there is no risk that would cause illness to its employees.
Yes.
Now, that's one side. Now, there are other laws, that employees can also call upon, maybe even the employer, the Employment Equity Act and the Constitution, which is the supreme law of the country. So what is the relevance of those in the topic that we are talking about today?
Well, in the sense of what you told me about what Israel is doing in granting added benefits to employees who take the vaccine, that may become a problem in South Africa because the Employment Equity Act does not allow an employer to act arbitrarily in its conduct with its employees, and any form of discrimination which is not justified on various grounds, and I don't think we'll have time to get into all of that, would be considered arbitrary and could be stopped by employees. So if one would not be able to find some form of justification for some carrot and stick approach to get people to vaccinate, I think you may run yourself into the whole Employment Equity Act and the fact that you cannot discriminate. The Constitution, and people are very quick. I've seen a long article written by Solidarity. I think it was probably in response to my article, relying very heavily on the Constitution and the rights enshrined in the Constitution: right to human dignity, right to life, right to bodily integrity, right to freedom of religion, belief, and opinion, right to an environment that is not harmful to their health. You know, those are the basic rights that I think people will try and rely on in saying they do not want to be vaccinated. What people seem to what they seem to lose sight of is Section 36 of the Constitution, which says that every right, fundamental right in the Bill of Rights, can be limited by way of laws of general application, if there is a good reason for it. You know, the importance of the purpose of the limitation, the nature and extent of the limitation, the relation between the limitation and its purpose. So in my view, that limitation clause will definitely find application when employers start saying, I insist I insist that you must be vaccinated. And therefore, given the greater good of society with a vaccinated workforce than a non-vaccinated workforce, I think that the scales must tip in favor of an employer being able to ask that its employees be vaccinated, because it would be for the greater good of the group, of all of the employees. So I am quite convinced that it should prevail, that you're entitled to do so. It may be that in small organizations, if an employee can make a good case for the fact that he can do whatever he does without having to come to the office, that it may be difficult to enforce it on such an employee. But I come back to that point that it is always managerial prerogative to decide how a business operates, because it's the shareholders who put the money in, who wants the business to be successful, you know, and it's for them to decide how the business runs. It cannot be the other way around. So in that sense, it appears to me that the Constitution will definitely come to the forefront of this dispute. I'm not suggesting at all, and please do not misunderstand me, that if someone cannot be vaccinated because of a medical condition, let's assume pregnant women can't be vaccinated. I'm obviously not suggesting that you could insist on that. I'm talking healthy people who can be vaccinated. My view is that an employer would be able to insist.
Yes, just back to that limitation clause, just to to help some of us. So, under what circumstances does that limitation clause, apply with regards to the laws of general application? I saw something about reasonability and things like that and stuff.
Yeah, the statute, Section 36, says that it will apply to the extent that the limitation is reasonable and justifiable in an open and democratic society based on human dignity, equality, and freedom. So there will have to be a reasonability element to it, and then also the things that I've already mentioned: the nature of the right that you want to impose, the importance of the purpose of the limitation. Now, I think therein lies the coming home for employers, is the importance of the limitation that you wish to impose. As soon as the medical fraternity is able to say, and I don't think it admits of any great doubt anymore, that vaccines are not harmful. They are actually very good for human life. The moment we pass that is going to be the moment where employers are going to say, well, it's going to be better for everyone if my workforce is vaccinated, and therefore the limitation I wish to impose can never be said to be so horrendous that it cannot be imposed.
Yes. Now, about a week or two ago in Israel, I'll keep on coming back to Israel because, like I said, they are the country that has done the best in terms of vaccinating its population. They were the most aggressive, and now we are learning from them as the whole world. And one of the things that has just come out from Israel is actually literature that proves beyond any reasonable doubt the fact that when you vaccinate your people, when the majority of your people, overwhelming majority, are vaccinated, you can turn around, the course of this pandemic. And that is literature that has been published in reputable, medical scientific journals, which proves that point. So therefore, I think with them having done what they've done, and it's being backed now by literature, we are getting closer then to a situation where, employers may actually start to think. I know within South Africa, we are saying it is going to be voluntary for everybody to take the vaccine. But in the workplace, if as an employer, I've got this obligation to provide a safe and healthy work environment for my employees, and some of my employees do not want to take the vaccine, and therefore that weakens or makes it impossible for me to meet that obligation, then one may have to then say, is this thing proven beyond any reasonable doubt that it actually saves lives? And the literature from Israel is actually showing that. So,
yes.
Yeah.
And in that, and I think given that the world is slightly ahead of us, we'll have the proof of the pudding available to us when the mass of our population gets to be vaccinated. And I think what you would find is it would be the fact that it is for the greater good that would prevail. And yes, I understand the president has said that no one can be forced. And that is so from an individual perspective, but in an employment law perspective, I'm convinced that an employer would be able to insist. And I want to just quickly say that it will not be, I'm not suggesting that employers would be able to tie their employees down and have them forced vaccinated. I've never said that. When I spoke on another platform, the question was put to me in that sense, and that's not the intention. But I think there's other ways of insisting that people adhere to what you ask of them, because you would be, there's a whole host of remedies that employers may have to try and force the vaccination issue. And I also think we will never get to this whole thing that I do not really understand well, but that everyone talks about, and that is herd immunity. If there's not a little bit of an incentive for people to vaccinate, and that is that they keep their livelihoods going.
Yes. Now, I mean, a related matter, which is now more of indirect pressure on people to vaccinate. If, for example, a business is in the business of tourism, or in the business where you have to visit other countries, and those countries impose a thing that if you don't have proof of vaccination, we are not going to allow you in, like it happens with yellow fever vaccines and things like that. So if my employee who plays that role of going to other countries, it is critical of, for them to be vaccinated. And if they're not vaccinated, they can't do their job. Then in that situation, then, I have to find a way of getting that employee to get vaccinated as an employer.
You see, everything boils down in employment law to the operational requirement of the company. And the example you gave of the American restaurant dismissing an employee as a waiter who would not vaccinate, you can obviously understand it, because operationally, if it gets known that that restaurant has waiters who may have the virus, who are not vaccinated, people may not go and eat there, and that kills off their whole operational rationale, if you want to call it that. So I think in instances where it is so critical, it would be far more obvious that you would be able to force it through. You know, if you take like underground mining, I think the mines would be able to insist on this, because people work in such close proximity, and you can hardly work in those circumstances with a mask on the whole day. And you're not going to have the place where you can sanitize your hands the whole time. So I think the mines and big industry where you have people on production lines working closely together will absolutely be able to insist.
Yeah. Now, in an event where an employee or a group of employees refuse, to be vaccinated, what remedies are there for the employer? Can the employer change, the conditions of employment unilaterally, to make sure that that becomes, a condition of service?
Look, there's a few aspects. I think an employer can give an instruction to say, my workforce must be vaccinated unless they can give me proof of medical condition. Let's take that one. If someone there says, I will not be vaccinated, that would be insubordination, and you would be able to discipline such a person for refusing to be vaccinated. You would also be able to, as you've mentioned, change your terms and conditions in living in a pandemic like we are, to say that you will only be able to work here if you are vaccinated. And then people will be able to try and fight you for that change in the terms and conditions. Now, in our law, all that you can really do is strike to avoid changes to terms and conditions of employment. Our Labor Relations Act does not really deal with the individual who doesn't want to comply. It deals with a group. So where you have mobilized trade union affiliated workforces, they would be able to strike on this issue and say, we will not do this, we'd rather go out on strike. Then it will be no work, no pay, and one will see who will blink first. You can also find that an employer would have the following remedy available to it, and that is to say, those people who are not vaccinated, I will lock you out, and you cannot enter the premises, and I do not have to pay you. So you can stand on the pavement, and I will not allow you in, and I will not pay you. A very controversial remedy, but it's definitely available. The one that I think you may find that would also be utilized quite quickly by employers would be the one where they start a retrenchment process. Now, employer can embark upon a retrenchment process for economic, technological, structural, or other reasons, and I think it would be a proper ground to say, I need a workforce that is vaccinated so that I do not have these risks attendant upon people that's not vaccinated. And if you do not want to be vaccinated, then I'm going to have to retrench you.
Yes. And so that falls within, you mentioned about 3 or 4 grounds, for retrenchment. Or restructuring. One of those was operational requirements.
Yes.
So that would be within operational requirements.
Yes, correct. And what makes it worse is because in labor law, if you offer someone, if you go into retrenchments and you offer someone an alternative post and he refuses to take it, then you can retrench him without paying him severance because you've offered him a reasonable alternative. I think that offering people to say, you can keep your job, but if you do not want to be vaccinated, you're going to lose your job, and I do not have to pay you severance because I've offered you a reasonable alternative.
Wow.
Yeah. No, it can be quite.
I was like, okay, so I can actually, the guy can actually go without any severance package. But now you are explaining that
Yes.
because they've been offered a reasonable alternative, because as part of the retrenchment consultation process, once
Correct.
I've given a notice to retrench and I give you alternatives
Yes.
that are reasonable, and if you don't take them, then I can dismiss you.
Yes, and then you're absolved from having to pay. That's what the Act says, the LRA, Labor Relations Act.
Yes.
So I think you may find also that people may resign in protest and try and claim constructive dismissal. I think you may find that would also occur, but I also do not believe that that could ever be successful, because it's not the conduct of the employer really who causes who causes you to feel that employment has become intolerable. It's really the pandemic, if you boil it down. It's, you know, it's not, the employer is not being unreasonable, he's actually being very reasonable. Yes.
So, and then what would be the role of CCMA? You know, because, you know, let's say in that case of somebody resigning and alleging constructive dismissal, you know, my experience when it comes to CCMA, which is nothing compared to your experience, you know, and the labor courts. But my experience is that the commissioners, they tend to have a soft spot for employees, you know, even in situations like this. So do you think, you know, this, you know, the argument you've put forward, that, you know, it is not the conduct of the employer that has led to this thing, it is actually the pandemic itself. Do you think that would fly?
My experience of constructive dismissal claims is that the CCMA, especially in the jobs bloodbath that we are experiencing currently, the CCMA looks quite askance on someone who gives up a job, a perfectly good job, for not a wonderful reason. So I'm not someone who advises a client easily to claim a constructive dismissal. You know, I always maintain that that's for those sexual harassment type cases where the secretaries cannot cope with their boss's advances. That's the textbook example of a constructive dismissal, and those they will succeed. But I'm not sure that in this context, giving up your job for not having the jab is going to sit well with the CCMA commissioners.
Yeah. Okay, but there's another area that we did not touch on. After an employer has unilaterally changed conditions of employment.
Yes.
In environments that are unionized, where people are organized, is there a way that the employees can actually stop the implementation of that,
yes,
you know, unilateral change in the conditions of service?
Yes. The Act allows for them to rush off to the CCMA to get an order to say to the employer to stop the change for 30 days, only 30 days, whereafter, if the employer then still wants to change the terms, it can go ahead, but the employees then immediately have the right to go out on strike. Yes. So it's really just a dilatory remedy. It can stop the employer by 30 days, but no more. Thereafter, yes, it's back into the whole issue of power play and deciding who's stronger, the employer or the employees.
And so during that 30 days, it's meant to enable them to try and reach some common ground.
Absolutely.
But if they can't reach common ground, the employer can then go ahead and implement the changed, you know, conditions of service.
That's correct. Yes.
And the remedy on their side is a strike, but also from the employer side is that then you can, you know, lock them out.
Yes.
You know, and don't have to pay the employees.
Yes.
You know, it's a no work, no pay kind of situation.
Yes, that would be a defensive lockout where you just react to the strike. But you can also, and that's also what I said in my article, you can find an employer can go on to an offensive lockout without people saying they would strike. Employer can say, until you're willing to take the jab, you stand outside and I'm not paying you.
And that's perfectly legal.
Absolutely. There's some requirements in terms of the LRA that you have to go through, but it's procedural requirements. It's not anything that's difficult to overcome.
Yes. Now, another question that comes up then is, who pays? In a situation where the employer is enforcing that employees must take a vaccine. And let me be much more specific. Some employers subsidize the medical aids to the tune of 50% or 60%, 70%. So if I insist as an employer, then that employees will have to get the jab via their medical aids, because I'm heavily subsidizing them, do you think that would be something that is reasonable to do as an employer?
I think if an employer wants to insist on vaccination, and it's not where we are currently, where the government says everyone will get it for free, let's assume, just for the sake of argument, there's now an ability to get the vaccines quicker, and an employer decides he wants to get this done quickly, then I think he would have to pay. I doubt that an employer would be able to insist on something and have the employee pay for it, who even doesn't want to do it. So I think if there's any cost to occasion to it, the employer would have to pay it.
Yes. Now, in the event that an employee suffers an adverse effect based on the employer having insisted that they must get the jab, what is the liability to the employer in such a situation?
You're not asking difficult questions. It would, it's going to depend on many things. It's going to depend on I suspect, and I've not really given this much thought, but I suspect if you insist, you would probably have to pick up the medical bills if something goes wrong. I think that would probably be what is expected.
Yes. Okay. All right. Now, but maybe let's just go slightly beyond this topic. Is there an area around this topic that you also want to just add that may not have been in that article when you wrote in December?
The only thing that I have given a little bit more thought to than what is in here is this ability to differentiate between employers that absolutely must have their people vaccinated and those who maybe it would not be such a big deal for them to have them vaccinated because they are coping quite well at home. And I think there may be an argument to be made by employees in that circumstance that says, well, we've now worked at home for a year and we are working equally well as we've worked when we came to the office.
Yes.
So it may be that limitation in the Constitution will be more difficult to sustain. Where you have that situation. But I come back to the fact that I think employers would be within their rights to say, I never wanted a business of people sitting at home, working from home. I wanted a business where we all congregate in a place and I can watch everyone. Because if you go back to the very, very basic principle of employment law, it is that you must make your services available to your employer, and if he doesn't have work for you, then you still have to pay the employee, and he controls the work that you do. Now, I know in the times that we live in currently, that seems to be quite a laughable proposition, because we have gone so far beyond someone watching over our shoulders how we make widgets in a factory. But the fundamentals of employment law remains, and that is that the employer can prescribe where you work, how you work, what hours you work.
Yes. Okay. All right. Now, I think we've covered quite a lot in this area. I normally ask, some of my viewers to ask 1 or 2 questions. So I just want to see if there is any question.
Okay.
All right. So, should an employee suffer adverse effects due to the vaccine? and the employee doesn't have medical aid and there's no contract in place stating that the employer will carry medical bills, I think we've already answered this question.
Yes.
That the employer, obviously there are a lot of things that need to be considered, but if it was initiated by the employer, then the employer would have to be liable, to deal with that kind of situation,
Yes.
including whatever medical cost, whether
Yes.
it can be seen to be an injury on duty or not, I don't know. if that would
No, that's why I said it's a very difficult question, because I'm sure that there will be all kinds of legal challenges to that, and on questions such as causation, and was it the vaccine or was it an underlying illness, so it is a bit of a minefield. But I think an employer who insists must at least do the right thing and pay for the medical bills.
Yes. So when we just look at this whole topic now that we've been covering for the last 35 minutes, so the bottom line is an employer can actually enforce a situation of vaccination. Obviously, there must be, a reasonability, and I think it must be something that takes into account the rights of the employees. But at the end of the day, an employer can actually enforce it. And if an employee refuses, it may actually lead to a dismissal.
Yes. In the broadest sense, I will hasten to say this. I suspect that this would end up very quickly on a very fast track in the Constitutional Court for adjudication once and for all, because it is an emotive topic. I've seen how many people have reacted very badly to my views.
Yeah, and I mean, some of your colleagues or counterparts, they've also written, from different, firms.
Correct.
There are people who are strongly objecting to how you are looking at this matter. And what is their objection, or on which areas do they look at things differently?
Look, the solidarity article that I saw was very much from the viewpoint of labor, of employees who do not want to be vaccinated. What I've also seen is people taking this on from the categoric objection, like a religious objection. I do not want to take it because it's against my religion.
It's against the things like the 666 and
Indeed.
A and things like those.
Indeed, yes. Yes. As I say, look, there's not been a case on this. My view was formed from basic principles and first principles of law. And also with I would suggest, and maybe people will tell me I'm mad, a little bit of common sense thrown into it, because it seems to me that we must do what's for the greater good of society, and it clearly must be for the greater good for us to get through this thing.
So in the article, you mentioned that, if it's refusal on medical grounds, that one, it may be difficult, for the employer to enforce, and it makes a lot of sense, because then in that thing of limitation of what is it now? Limitation clause in terms of the laws of general application, it would be found to be unreasonable.
Correct.
To enforce somebody who's got a medical, like somebody who's got a history of allergies to vaccines and tablets, and you then put them in a situation where they may actually react, or a pregnant woman, like you mentioned, where the vaccines have not yet been tested on those kinds of people. So I understand that one. But on the issues of religion and culture, you mentioned that may not fly, if employees actually use that as a reason to say no to a jab.
Look, I don't think you can be forced. So you can say no, but you may lose your job by saying no, because in my view, if if the science shows that the vaccines aren't harmful and they are massively beneficial, then in that weighing up between religious belief or cultural belief and the greater good of society, the greater good of society must win.
Yes.
And then if someone feels that strongly, and hey, we've seen people feel very strongly about their religion on other topics, where you then get to a point. I've had a guy who would not work on Saturdays because of his religion, and when it became such a problem, the employer had to retrench him because it was a contract that they won, and then they had to all work on Saturdays, and this guy just refused. And operationally, it just didn't make any sense to keep him then, and we had a huge fight about it. But in the end, we prevailed, because operationally, you cannot expect of a business to be hamstrung in that sense. So I think people will still take these arguments, and they will take them as far as they can. I'm just suggesting that it may lead to them having to either not work at this place, finding a different place to work, but I'm not ever suggesting people will be held down and vaccinated.
Yes, no, lovely. Now, my last question, as we get to our 45 minutes. Now, this one is not from the same article, but it's from another article of yours. So that you wrote early days, early days of the pandemic in March last year. You had written about the rights of employer in the face of coronavirus. Now, this one it's about issues of downscaling of operations, short time, and layoffs. All right, just
Yes.
a little bit around that. Now, we have seen a number of companies since last year, downscaling their operations. I mean, one is the Greyhound bus,
Yes.
the bus company. The last day of operations was the 14th of February. I don't know why they chose Valentine's Day.
Yeah, it's very odd.
as their last day. But anyway, that company took a decision. We are stopping our operations in South Africa, and that led to layoffs.
Yes.
Many other companies have done the same. Others have gone into voluntary, what do you call it?
Liquidation.
Voluntary liquidation, others on business rescue. So I just want to know, as somebody who is in that space, have you dealt, and I don't want us to talk about specific companies, but what are the kind of challenges that have come your way around companies who take decisions to either, put company on business rescue or liquidation, or downscale operations or short time, things like those?
In the past year, it has taken up most of my time either to assist and guide in what the English law refers to as furlough, where you tell people that you can't pay them, they must sit at home and wait until there's work for them again to do. Short time, putting people on extended non-paid leave, all of those topics. And it all actually eventually boils down to whether it can be suggested to be an alternative to people losing their jobs. Now, obviously, I think everyone knows that there's been a massive jobs bloodbath, and that's unfortunately for me a topic that has also occupied me quite extensively in the last year, is the advice I've been giving to companies who just had to halve their workforces, especially in the tourism industry. It's been a nightmare for anyone who relied on external visitors, because the borders are basically closed, because no one is going to come here and sit in quarantine for 2 weeks before they can do anything. So it's been quite hard, and all of those topics eventually, in my view, boil down to trying to save businesses rather than let them perish.
Yes. All right, Danie, I think we have come to an end in terms of the discussion, the topic of discussion today. I had promised that we'll take 45 minutes, and it's exactly 45 minutes. So I want to thank you for giving us your family time to actually, inform our viewers about this very important matter. And I think, as the rollout gets more advanced, we are going to see some case law coming out of this particular area.
I've little doubt, and it was really nice to chat. Thank you for having me.
All right. Thank you very much, Danie.
Thank you.
All right. Thank you to all our viewers. I hope you learned a thing or two about, the considerations from a legal point of view as far as vaccination in workplaces where employers may insist on everybody being vaccinated, and what leeway do you have as an employee, but also if you are an employer, what are the things that are within your rights to do. So we will leave it at that, and thank you once again, Danie, and have a lovely weekend, and to all the viewers, have a lovely weekend. Thank you.
Thank you.
All right.